Hi there, Brian Simo here, personal injury lawyer and partner with Ross McBride. Prior video, I talked about different steps in litigation.
Previously on Brian Simo, attorney at law.
Let's talk lawsuits.
Now back to your regularly scheduled program.
Today, I want to talk about one of those specific steps, and that is an examination for discovery. So an examination. When I say that word, it probably conjures up some unpleasant memories for you. Maybe sitting at a desk in an auditorium in high school, trying to regurgitate history facts. Maybe sitting in a doctor's office getting poked and prodded. Thankfully, this is neither of those things. An examination for discovery, which is often called a deposition if you're in the United States, is a question and answer session under oath with a reporter present, a reporter being a court reporter, not somebody who's going to the news, where you're asked questions that are relevant to the case that you've brought or that has been brought against you if you're the defendant. As I mentioned, it's under oath, meaning that you have to tell the truth.
I can't lie!
That's important, and it's important to keep in mind during the entire examination. Now, you may actually be more familiar with this concept than you realize, and you've actually probably seen one before if you've watched any TV, and I'll give you some examples. In the movie The Social Network, the actor who plays Mark Zuckerberg is actually being examined by lawyers in a court reporter's office. That's what you're seeing. You're seeing them ask him questions relevant to lawsuits brought by other potential co-founders of Facebook. Now, in the United States, they seem to like to videotape these. In Ontario, thankfully, we don't do that. Instead, we do them either in person in a court reporter's office, where a transcript is kept, not a video by a court reporter, or we do the same thing on a platform like Zoom online, which has become much more common post-COVID-19. So what happens is you sit in a room or online with your lawyer present, and the lawyer for the opposing party asks you questions relevant to the case. It's as simple as that. Think of it as the longest and probably the most boring job interview of your life, but it's not about a job. So what's the purpose of this? Why do we do an examination for discovery? Well, a couple of reasons. Number one, litigation is not meant to be a surprise, as I've mentioned in a prior video. The parties are supposed to know the details of the case brought against them or that they are bringing. That has to be disclosed. We work on a system of disclosure of evidence to the other side. The other reason is that you want to try to get admissions from the other party during the examination. Now, admissions makes it sound like someone is admitting, guilt in a criminal case. That's not usually what we mean by admissions in civil litigation. An admission may be something very non-controversial, but it allows us to not have to prove that at a trial. I'll give you a good example. I'm often trying to get an admission from a defendant in a car accident case on who owns the vehicle. It's usually not controversial. It's usually the driver of the vehicle, and they usually readily admit that when asked. Your lawyer will be present during the examination for discovery, but their job isn't really to answer the questions or provide evidence, although they may assist slightly from time to time if people are stumbling over something. Really, their job is to make sure that the questions being asked of you are fair questions, that you're not being asked the same question more than once, and that the questions being asked are relevant to the case. So what are some tips for you if you're a person who's about to be examined in an examination for discovery? Well, it's actually not that complicated, and I like to distill it down into 4 easy to remember points. The first, and the most important, is something I've already said.
Flashback to 2.5 minutes ago.
You have to tell the truth. Even if you think the truth hurts your case, tell the truth. I always tell clients, we can deal with evidence that isn't helpful. I cannot deal with lies. Lies ruin a case faster than anything else. But when I tell clients that, usually the response I get is, well, of course I'm going to tell the truth, Brian. I have nothing to hide. But people accidentally don't tell the truth all the time. We say things like always or never, and we use absolute terms. That's okay when we're talking to, a friend over a beer or a coffee. It is not okay in a legal proceeding. An absolute term means absolutely every time or absolutely never. So be careful with those terms because they can make you sound uncredible when you're not and you have nothing to hide. The second tip, listen to the question and answer the question you're asked, and only the question that you're asked. That can actually be harder to do than you think because people have a tendency to start telling a bit of a story and sometimes, frankly, to ramble on a little bit out of nerves or just because they're not sure what the other person is looking for. It's meant to be a question and an answer, a question and an answer. The third point I tell clients, don't guess. This isn't the time for that. It's okay to estimate as long as you're making it clear that you're estimating, but don't guess. Don't come up with an answer that is going to be easily provably wrong because it makes you look like you're not telling the truth. If you don't recall dates and times, that's okay too. Simply say, I don't recall. It's meant to be your evidence to the best of your recollection. It's okay to not remember exact dates, times, places. It's quite normal. It'd be a bit odd if you did remember all those details.
Weird.
The fourth point, a court reporter is trying to keep a transcript and create a transcript of this exchange. That transcript is used in a court proceeding. And what that means is it's really important not to talk over each other. They cannot record and transcribe people talking back and forth at the same time. And it sounds like that's logical and makes sense and easy to do. It can be harder than you think. It's quite normal when we speak to each other that we interrupt questions with an answer before it's finished. It's quite normal that we jump in on each other just to move the conversation along. It doesn't mean it's rude. It's quite normal to talk that way. It doesn't work in an examination for discovery. Hear the question, wait for it, make sure it's finished, and then answer it. Answer questions, be helpful in providing your evidence, be clear if you can. Do not challenge the relevance of the question unless your lawyer challenges the relevance, and let them have that discussion and argument. It's not your job to do that. I hope this information has been helpful. Try to follow those tips and you'll get through it just fine. Thanks. Have a great day.